All right, hi. Welcome back, class. Hopefully everyone had a nice week so far. By this point, I think everyone but one of you has actually talked with me about your paper, so I think you're in good shape. If you have any questions before the deadline on Sunday, try to get to me by Saturday morning, and if you get to me by Saturday morning, I will promise I'll get a response. If you don't get to me by Saturday morning, I won't promise I'll get your response, but I'll do my best. As far as the topics you've all picked, for the most part, they're pretty good, and I think they've really found a way to integrate whatever you're interested in with the separation of powers, which is exactly what I wanted. Again, by Sunday at midnight, don't miss deadline, please. I want your paragraph. I'm talking 5 or 6 sentences, which breaks down your topic, what you want to address, what your thesis is. I don't need a final answer, but generally, what is it that you're trying to accomplish? I think that'll be sufficient. Just know you're heading in the right direction. It's possible that after you submit your paragraph, I may ask for some revisions. A couple of you have already done so. I've given you slight revisions. You've made the changes, and everything's been fine. So try to, as best as you can, faithfully execute my suggestions, if you will. Because I'm not doing this because I want you to write something. I'm doing this because I want you to start a paper topic that will be meaningful. You can actually finish. It's very, very easy in this class to go astray. And once you go astray, you can spend weeks in a direction that winds up as a dead end. I will do my best to not let you do that. So listen to me, and I will try to give you the best I can do. Okay. Any question about the paper, about the deadline, or anything about that? Anything in your minds? Nothing? Okay. Suit yourselves. A note, we may have a special guest tonight. You may or not know, but the American Bar Association is holding their annual meeting across the street at the Convention Center. So there are thousands of lawyers right now in Texas who are visiting from all over the place. One of them is my former boss, Judge Danny Boggs, who is a judge in the 6th Circuit Court of Appeals. He may pop his head in that door for a minute, so I may excuse myself and welcome him in, and he can say a few words about the Constitution or whatever. He's a brilliant judge who I'm very blessed to have had the chance to work for. One thing to know about Judge Boggs is that his hiring process for law clerks is very unique. He sends prospective clerks a list of trivia questions, like Jeopardy questions, a Trivial Pursuit, not just on law, on math, on science, on literature, on history, on philosophy, everything. And you basically have to get a very good score to even get an interview. So from the thousands of people that apply, he winnows it down to about 50 or 60 and gives them this trivia quiz. He doesn't like the word trivia because he thinks it's not trivial. It's quite important. And then based on that, he interviews you. And someone's saying, oh, why can't you Google it? Well, during the interview, he asks you, so how'd you get this answer? Or where'd you learn this? And he'll smoke you out very quickly if you cheat. I think 2 or 3 of his clerks have gone on Who Wants to Be a Millionaire and have won significant amounts of money. So he's a polymath, if you will. He knows just about everything. He can recite chapters from books from memory. So hopefully he'll come by. He may not. He may just blow me off. But he told me he was on his way. So I will.
What kind of, like what's an example of a non-law, like just what can I do that? I'm sorry.
I'll show you the quiz.
Oh, okay.
After class, I'll show you the quiz. Okay.
Okay.
Remind me. Okay. Anyone wants, I'll show it to anyone who wants. But the questions are hard. They're hard. Like who are these various figures in history, and how much, if the moon was made of cheese, how much would it weigh? And like really.
What?
Yeah.
Do you know the answer to that?
You work it out.
No, but do you know the answer to the cheese?
You don't need to know the answer. You have to have a thought process of how you'd work it out. Well, here's what cheese weighs. Here's the relative density. Here's a rough circumference of the moon. If you do pi, you can find the volume of a sphere. I mean, you work out the steps.
Oh, okay.
Anyway, but so hopefully he comes by. I may pick his brain. But today we are talking about a topic that is very hot. And Dad asked me a moment ago, didn't you write this a couple weeks ago? And the answer is yes. I wrote this paper in January. So the reason why I wrote this paper is because we are now in a situation where there are a number of lawsuits being filed across the country that challenge the president's failure to comply with this provision of the Constitution. the take care clause. So historically, the take care clause has been used in a very different context. So imagine this situation, right? I'm sure you studied in ConLaw the removal powers, right? Can the president fire someone from the executive branch by himself? Or does Congress need to give its consent? And this was a case of Myers versus United States, Humphrey's executor, and Morrison versus Olson. Right. Can the Senate put strings on removal? Can the Senate say, you can't fire someone unless you give good cause? So the president, who won those cases in each situation, said, or at least in a couple of them, wait a minute, are you telling me that if the president before me appoints someone, I have to stick with him? What if he doesn't agree with me, right? What if he frustrates my ability to do my job? What if because of this holdover guy, I can't faithfully execute the laws? So think about that for a second. The president in the past has argued that constraints put on the presidency by Congress inhibit his ability to faithfully execute the laws. Everyone follow me? That's traditionally how the take care clause was understood. Is Congress getting in the way of the president executing the laws? Is Congress putting all these unconstitutional restraints on the president? That's not what we have here. What we have here is something very different. Rather than Congress getting in the way of the president executing the laws, Congress is alleging that the president is disregarding the laws. The state of Texas is alleging that the president's not enforcing the laws. They're both arguing that the president has failed to faithfully execute the laws. This is a really novel and new constitutional claim. To my knowledge, there's not been a single court decision ever finding that the president or the executive branch failed to faithfully execute the laws. And there may be a couple of reasons for this, right? One reason is that traditionally the president enforced the law, whether he liked it or not. Another reason is that generally if the president's exercised perhaps discretion of maybe not enforcing as strongly as Congress liked, usually the other party didn't really complain that much. They challenged it politically. They said, oh, this is bad, we need to elect someone else, or we need to put different people in office. Maybe they thought of going to court about it. But the problems that present themselves with this case is that the federal government, the Congress, and the state of Texas, joined by 25 other states, have challenged the president not politically, but judicially. They filed lawsuits alleging that the president failed to execute the law. This raises a lot of issues. And one point which I want to stress to you is that, generally speaking, constitutional litigation takes time. To give you an example, the Second Amendment, right? Some of you may know in 2008, the Supreme Court held in the case called District of Columbia versus Heller, that the Second Amendment is an individual right. What you may not know is that there was 20 years of scholarship, of debate, of thinking about the Second Amendment. Does this only apply to militias? Does it protect an individual right? There's a lot of stuff that happened leading up to it. And the arguments, by the time they got to the Supreme Court, were pretty well, argued, pretty well developed and debated. In contrast with Obamacare, right? I think I used this example. If in 2009 I had asked any of you in this classroom, can Congress require you to buy health insurance? I answered the question, of course they could in 2009, because there was really no legal arguments why they couldn't. But between 2009 and 2012, when the Supreme Court decided the Obamacare case, these arguments developed really quickly on blogs, right? On Twitter, right? On Facebook, on professor debates. So the arguments that the Supreme Court used to invalidate Obamacare came up really fast in the span of really 6 months to a year, okay? This case is even faster. Why is it even faster? Because the Affordable Care Act was debated in Congress for almost a year. right? We knew it was coming. The bills were a draft, whatever. But when the president issues an executive memoranda that becomes effective in a few months, 90 days to be precise, there's no debate. There's no argument. Piece of paper, there it is. That's the new policy. So there hasn't really been a sufficient amount of time to analyze the constitutionality of this policy. You know, there have been some blog posts, and I wrote probably the only articles that exist. There'll be others, but I wrote the only two that exist. And I'm sure I'm making mistakes. Positive, because it's such a novel and new topic. And already, as I mentioned, there's been a court case filed in Texas. I filed a brief in that case. The arguments have developed in the span of 2 months. The first rounds of briefings were not very good. The second round of briefing got better. And then just a few weeks ago, there's a third round of briefing. It's getting really good. And this will probably be on appeal next month or so. It'll get even better. So it's fascinating to watch in real time how constitutional arguments develop and flourish. Because what happens is advocacy. One side makes a good argument, and the other side says, oh, wait a minute, here's a better argument. And they keep going back and forth. And this refining of the argument works. It's not ideal. It's much better to argue these things outside the context of litigation, right? It's not a good way to develop legal arguments in court. They should be developed beforehand. But these are the circumstances we find ourselves in. Because again, on November 24th, the president issued a memoranda, and that's it. There it is, 90 days, got to go. So there's not even a challenge to debate it. You have to basically go full in. Okay? So this class is also somewhat selfish because I'm here to hear what you think. Because again, these arguments have not been fully vetted. I've changed, since the version you read, I've changed your article a couple times more based on things that other people have written. Okay? We don't have a Supreme Court case about the take care clause. If you look through your book, there's like 2 pages on it, right? Because it hasn't really mattered. But now, I think the court will have to look into this. And we have a special guest. Come on in, everyone. Please welcome my once and former boss, the Honorable Danny Boggs of the U.S. Court of Appeals for the 6th Circuit. He is not just a judge, he is a fellow. Judge, what's a fellow?
A fellow is somebody who gave the ABA a certain amount of money.
And
Bar Foundation fellow. More money, you get a different color or a bigger color. And as many, it's like being a donor to law schools, right?
I think that's good. And Judge, remind, okay, I have camera. Do you want me to turn it off, or are you okay?
Whatever you want.
Okay.
The electronics are good, but the local GPS is not. I'll go into that later with you.
So, Judge, what wisdom do you have? If you have a moment to share with these are second, third year law students who are taking my class in the separation of powers and federalism. What wise words would you impart?
I don't know about any wise words. Being a federal judge, of course, you have concurrent jurisdiction, obviously, where in the sense that constitutional issues can come up at any level, so you don't have to practice in federal court to raise these same kinds of issues, because you may be either on the attack or on the defense in state court, where either you're trying to do something and one side or the other is saying that federal interests trump and others don't. But obviously the mechanics and the details are what you're learning from Professor Blackman. But you certainly don't have to say that you have to be in federal court. And of course, I guess with separation of powers, that's a little different from separation of courts in terms of whether you're trying to get out of state court into federal court or vice versa, because that's certainly a lot of what we deal with. But the general topic of separation of powers is a hot one. I don't know if you touched on Hamburger's book on administrative law and whether it's unconstitutional or not.
What do you think of the book?
I haven't. I've just read reviews, but it's interesting. It's Philip Hamburger's a professor at Columbia who I think is more noted as a First Amendment scholar, but he has religion clauses, but he has a book on the evils of administrative law, and I guess how instead of administrative agencies, it should all be in real courts, which has some merit. On the other hand, a lot of judges would be just as happy if
Mhm.
they didn't have yet more work to do. So, I mean, I don't have any, I didn't plan any great wisdom. I'm available for questions or inquiries.
Maybe, Judge, are there any federalism separation of powers decisions you worked on that you might want to talk about?
Yeah, it's a good question in the sense of under that heading. I mean, we just did some stuff on Second Amendment rights.
You did have that decision.
But that isn't, well, it sort of is in the sense that in that case, the gun control laws say that there are whole categories of people that can't have guns, the minors, foreigners, people who have mental disabilities. And in our particular case, it was about people who had a mental commitment however long in the past. But the structural issue, in part, was because Congress had said, but you can have these disabilities lifted through a certain process. But then they didn't fund the process. And then they had another law that said, well, the states can have a process, but only if the states agree. And in our case, the state hadn't agreed. So this guy had no process. But it does raise, in that sense, issues that are both administrative and then who do you allow. And in our case, you didn't have these processes, but if you did have them, they were relatively administrative. You went to the Attorney General or you went to some kind of state body, which then had some type of judicial review, or you could go to them. But you did have this interplay of what were essentially executive branch organs, with the courts only being involved later, yet certain rights were involved. The case is Tyler, Tyler versus Hillsdale County, I think, because the guy was trying to get his gun in this county where the sheriff had said that he had not complied with the law.
One other case which we talked about was Schuette, the affirmative action case, which I think we worked on that term clerk. That's some interesting separation of powers dynamics.
I mean, in what sense? In the sense that
The political process, yeah.
Well,
Structural.
okay. Well, if you believe in the political process doctrine at all.
I
But
have at least one student writing about that case.
but the sense of the separation of powers, it's more state versus federal, I guess. But it is also, can the judicial branch stop the legislative branch from the people as a legislative branch? Because that's, in a sense, I mean, I guess I don't think of that as separation of powers as much as can the people be part of the legislative branch? That is, at least most of the briefing would have said if the Michigan State Legislature had simply passed a law, it would probably be okay. At least they wouldn't have the same political process doctrine.
Interesting. So today our topic is the take care clause, which I'm not going to ask you to weigh in on. But one of the broader issues we're discussing in this class is to what extent should the judiciary react when different branches grab power? So often, sometimes maybe Congress grabs too much power and the courts can realign it. Sometimes the executive grasps for too much power and the courts realign it. But what happens when they're both at loggerheads and they're both trying to grasp all they can? What do you see as the role of the courts in this case when you have these truly political disputes that have these constitutional undertones?
Well, I would say you look to what the Constitution says, that is, thinking about, are people grasping too much power? You know, there isn't something in the Constitution that says one branch shall not have too much power. It says you shall do something, you shall not do something. I mean, the classic way that you usually talk about this is the steel seizure case.
Yes, we did Youngstown.
Okay. In fact, there's an exhibit on the Magna Carta.
I saw it.
Which was at the Library of Congress, a huge exhibit, but over in the Hotel of the Americas, there's a small group of it, one of which has the steel seizure. It's a cartoon, shows this big hand coming through the Constitution and seizing the steel mill.
I have that one. Yeah.
Okay.
I got that one. Yeah.
Yeah. But you know, I guess I don't think of that. You can analyze it in a certain political science way, but as a judge to decide that issue, I would think of it as property being taken without due process, not is one side or the other having too much power, because as between the president and the Congress, a lot of times it's just, what each side politically can do. The president does something, let's say it's within his, let's assume for these purposes, it's within his broad constitutional powers. Congress could check him, but it doesn't.
And what's the significance of that acquiescence?
Well, I mean, if it doesn't contravene something, what I'm saying is that if I judge it in a political science sense that the president is grasping too much power, but Congress has acquiesced and it doesn't transgress some particular prohibition, so be it. And conversely, you got this back in the 60s and 70s with some of the foreign policy where Congress would allocate money or take money away only under certain conditions, and at some points the president didn't push back any further. You did, there are cases, Massachusetts versus Laird, where Massachusetts tried to say that the Secretary of Defense couldn't spend money. And
I think that decision actually gets in the take care clause the other way, that Congress is impeding the president's ability to execute the laws.
But of course, if Congress is impeding it by not funding him, that is its ultimate power. And again, that's a political, you see it in a political sense with all this business about, is the Congress shutting down the government or is the president shutting down the government? If the Congress passes an appropriation and the president vetoes it, then it's just a political argument about, is it the president who did it by vetoing it, or is the Congress that did it by passing a budget that the president will veto? And I don't see that the courts have a role in saying that one or the other is right. But now if the president tries to spend money that hasn't been appropriated, that's where you would get because the Constitution has clauses, money shall not be spent except by as appropriated.
Judge,
And
let me ask.
then you would enforce that. Or
Let me ask one more question. I'll open up to the floor.
Yeah,
one of the main issues with the Texas and Obamacare litigation with the Supreme Court is should the justices consider that their decision may have people lose health insurance, that the consequences of the Supreme Court invalidating certain provisions of Obamacare, for example, will result in people losing their insurance. To what extent, if any, should that weigh in a judge's mind?
From my point of view, not. I mean, it's I suppose there are occasions, but to me they're very rare, when rules or considerations are so evenly balanced that you say which will work. I see that more in a procedural sense, that if you're talking about rules of evidence or rules of procedure in court, where the court really has to make the law one way or the other. But I do personally, I would not say that, gee, I think this one is better than that one. There's a case, Miss Paula's Daycare versus something, where I enforced a wage law that was going to put Miss Paula out of business, which was probably a bad idea because the poor minors who sent their children to Miss Paula's Daycare couldn't afford any more, but that's what the law said. So I mean, there are lots of bad ideas. I think you can go to
hiring me is probably one of your worst ideas.
Well, I think it's President Grant's. I think it's Grant's inaugural that I know no means so efficacious to affect the repeal of obnoxious laws as their prompt and stringent enforcement.
Well said.
Yeah.
All right. Do you have any questions, guys, for the judge? This is your shot. Federal Court of Appeals judge in your classroom. Not planned either. You told me 15 minutes ago he was coming.
I'm supposed to be going up to this reception.
So
somewhere.
any questions for the judge? Oh, come on.
I have one that's it's a bit off topic, but maybe something you mentioned when you first started speaking, is we've talked a lot about the kind of the tension between the legislative and the Congress and the executive. But I wonder if you had any thoughts on maybe a tension between the legislative and the judicial branch when, let's say, Congress does maybe take jurisdiction and create administrative law courts, and maybe is any pushback by the judicial branch justified?
Well, I mean, part of it would be, what is it that they are doing this for? I mean, to take one end of it, if Congress says that if you contract with the government, then there shall be arbitration of that contract before some governmental body. I'm just kind of making this up, but that seems to be within the realm of contracting and spending money. Now, if Congress says we're going to remove jurisdiction from all search and seizure cases and give it to, Josh or somebody,
Bad idea.
right? Then probably you say, you have a right under the Fourth Amendment to freedom from unreasonable searches and seizures, and the courts are the ones that should enforce that, not some bureaucratic agency. So I think you just have to look at what it is. Certainly, the whole issue of can Congress strip the courts of jurisdiction sort of hasn't been brooded as much lately, but there was a time 10, 20, 30 years ago when there were a number of those issues that came up. Could Congress take all jurisdiction away from all federal courts? Well, that never got pressed to the final decision, but that would be a stronger version of it. And, we had the Civil War cases and so on. And the military commission cases raised that to some degree. The courts do try to police the fact that you have recourse to some court, but at the same time, they acquiesce in restrictions. The whole AEDPA, the
Anti-terrorism effective death penalty.
Right, the anti-death penalty and effective terrorism act, some would call it, means the federal courts, in conformity with a congressional statute, have given up a lot of jurisdiction or effective jurisdiction over habeas corpus cases by saying we are now required to defer to state court actions when we would not have done so in the absence of the federal statute.
Your court hasn't gotten that memo, apparently.
So they're getting it. They're getting it.
So the court with Judge Boggs on the Sixth Circuit, they are notorious for being reversed by the Supreme Court for their habeas prisoner cases. It's almost it's like a tradition every month or so. There's another one that comes down.
But no, I mean, if you look at our cases, you will see more recently
Into line.
more that are coming in.
Can I have a question?
Yeah.
I had a question with regards to shooting, because I know you,
Right.
You said that if there is a political process
Right.
doctrine, and you
Right.
said there's not really one.
Well-
What did you mean?
Well, I meant that
With regards to that case, I guess.
well, the cases that established the so-called political process doctrine were, I would say, fairly extreme cases where the Supreme Court was just sort of saying, in a racially charged area, you just can't do that. That they weren't very coherent. And in Schuette, the student side pressed that very hard, that they took the most juice we could squeeze out of it, and the Supreme Court just did not agree with them. There were several different cases and several different opinions, in the sense that you had the kind of hard line, the four, I guess, who pretty much said that.
Yep.
And then you had Kennedy, and then you had Breyer, who sort of said, well, it isn't completely gone, but it doesn't apply
But
here.
race matters.
Yeah, but race matters, but not in this situation. But the general notion that there's something that says that you can't change the political process in any way that disadvantages what are defined as racial minorities, I think is just not good law. And in fact, it's interesting, I think at the time, I don't know if we put it in, but we sort of looked at, had Akron and Seattle ever been applied to strike down anything in the intervening, what are we talking, nearly 40 years?
It didn't come up
And
anywhere.
the answer was zero.
Yeah.
So obviously we laid out our position, the majority in the circuit laid out its position, and things came out more on my
And your
side.
grandchild made a cameo.
Well, my not yet existent grandchild, or a hypothetical grandchild.
All right. Any other question? I think Judge has to go in a moment. Any other questions for the judge? No?
Okay, well, thank you.
I'm going to walk. Let's take a 5 or 10 minute break. We'll be back at 10 after. And I will walk Judge up to the reception.
Because it's very,
Yeah, of course. I'll be back. So everyone take a 10 minute break. We'll be back in 10 minutes. Okay?
very difficult to find your way around this building.
It's deliberately done like that.
Thank you.
Thank
Thank you.
It's to mimic the tortuous path of the law.
Did he just do a YouTube selfie?
Yeah, he was trying to like get him in the frame so bad.
He was like,
Oh,
oh, look at it. Here we go. Oh, here he is. Oh, it's really all-
I just don't want to like.
I love Yeah.
We'll be up next time.
Yeah, and it's already up. Like.
So, yeah.
No. Yeah.
If I have to.
Yeah.
The internet.
Why didn't you do that?
You should have asked him how much the room weighed. Jeez.
I still get no shoes.
I hope he comes back
I
for
was
like
like,
a
are you
glass of
sure?
wine.
Can I just grab the wine if you were my favorite wine? There is a No, you can't.
I have so much to do.
Because he was there, was the chief justice.
You're, like, he's gonna insert this stuff. You just put a time. He has no resume, no writing sample. It's not-
Well, I think we find as soon as he goes to shake their hand.
But he likes, Starbucks, so he thinks he can do it.
I know, I love all your.
By the way, just so everybody knows, it's still recording.
That's, yeah.
So, okay. Just saying.
So I'm gonna play.
I don't see anything that I don't say for, basis, but just in case people are interested.
Just watch how excited he gets when.
Because I was just asking.
How wide are you?
It was like.
Here, this is where I'm taking. Watch this.
Not what I wanted to do. Clearly.
Which is not the initials I
No,
go
yeah.
by. Yeah, and then so he's like, yeah, HJC, first of all, it's like, that's really weird. Okay.
Yeah.
And then he just says, what about hydraulic versus
Yes,
hydraulic
absolutely.
fracturing, like federal versus state control?
I did that exactly.
So eventually.
I even like.
That's why I'm like,
What's regulated by state.
You have to I have to.
That's
Slightly use it.
Oh, no, you can sell. Like, I have a lot of confidence.
Yeah, no,
But I just know I'm.
yeah, so that's all he said. He goes, I don't really want anything else.
No, I got here at 5:05.
Yeah.
And last week I actually.
Yeah, no, exactly. No, then we went to that, because
5:05.
he comes in.
Because most of them start 5:45. All my other.
He usually comes
So
on
why
water
didn't
and
like
like says that.
10 minutes?
Immediately.
But
3:30.
but yeah, I cannot get it.
I don't remember the name of the professor, but it's some.
If he wants to hang out here tomorrow night, but I'm working mandatory overtime, so
Yeah, about
probably
15 minutes ago,
7:30.
Ed came into my office and wanted to have his ridiculous long conversation. And I'm just like, 15 minutes is ridiculous. He also told us that one of the Texas Supreme Court judges just, there's like, I can't remember, he said it was on the record.
Yeah.
It's like a reference.
Yeah, I read that.
And so I didn't know stuff like that. And I'm like, trying to spread the word, like trying to spread the word. I go in my closet now, you should. I still don't. The thing is, old things, you know, even if it's a slight thing, if it's not, then you just put it.
I guess I learned.
But like, the whole just.
Who's really happy to have really cool paper ideas? Who likes their ideas? You guys probably really excited about what they're writing about?
Oriented stuff.
Yeah, that. And all the
No?
So they're gonna be like, they believe in. Yeah.
I'm like.
So
In
it's
six
right
minutes,
now.
closet and I was doing.
Yeah.
Right, that's a good.
I don't believe on his value, just for their like.
Yeah. I get
That's
to
what I
see
did.
it.
But what's nice is that can you sell like
Yeah, exactly.
$1,000
I just, it's so funny though that he-
Everything's been paid out and so I can put directly it's out.
Yeah, that's what I did.
But I try to figure out, take it out and again, things, take an hour, post everything, take pictures of it on my
Yeah,
phone,
exactly.
send it on there, and then I'm gonna put out. Yeah, I'm gonna go through and sell all
Yeah, those are good. It took me a minute to figure out why he does that, and then I figured out when he reads them when he has like a huge slide. where it has-
Yeah.
Make sure you always check no international.
Yeah.
But the good thing is, if you do
I had to
international,
like make a call.
no, if you do international, you can ship it to like.
There's a lot.
But they only ship to certain places. You can't see your equipment. But I know
You know,
the rep, you
And
can realize
the Army.
somewhere that wasn't on that list. And I
You
called
need
her
to
and I
work
was like,
harder
I'm-
on days where you expected not to be there.
You know what?
It's fine, you know, it's fine. Just send them a message. Yeah, you do
Right.
that she told me which one.
Yeah, no, we're in like, we're.
So basically, all, I'm only ever sure.
I had that, oops, I did it again.
Big rooms. Are you remember the oil and gas?
I had like, I said,
I tried.
That's the thing. There's one weird stuff.
yeah,
There's people in there.
And it's like,
really.
if you want it, I'll
Talked
sell
about
it.
it.
to you. That's awesome.
And they're
Yeah,
like,
it's weird.
And people would like things that are like that.
Because they're unfocused.
Some of my old neighbors.
like, asks money.
Well,
No, that's not society, that's a Facebook. Now you're not.
do it. The best way, what I do is I'll go up to the top.
Search it.
And I search it and I
You
see.
can sell like, you can sell one, you can either sell item like this.
That's the easiest way, because then I can upload.
It'll-
The information is already in there.
Yeah, but then they
That's
didn't.
so fast and easy.
I made 600 books.
I literally made 13.
No, I mean, it just says,
Like a random,
it's weird.
like an old purse that is a nice purse, but more volume.
Yeah.
That's really nasty, nasty. There, could people buy their books? Yeah.
See, my thing is like, I think.
Yeah, they're going, so what did you end up writing about?
Well, that's how they're starting.
So that's what 15 is.
Hey, it's $10.
But sometimes you don't do it. Well, that's how I was gonna be. Oh, wow.
I know, I'm going. I mean, I enjoy it. I like it. It's interesting. It's fascinating.
I was expecting him to really hard.
I made a joke in class about Sidney Poitier, and Mr. Colvin was the only one that laughed at that.
I like it.
But for whatever reason.
It's still a very hard one right now. I don't really know that. It's about like.
Like I learned something later on.
I reference a movie from the 60s.
Yeah.
Oh, Pokemon cards.
And my professor only speaks about.
Because those are gonna be worth something in the later date.
Yeah.
I'm not exaggerating.
For past
Like,
jurisdiction,
the Gilmore Girls.
to like, it's supposed to have a complete jurisdiction
Corporation.
on where they incite them, but then the 2005 Energy Policy Act gave like the state's ability to still, like, through the Clean Water Act. To kind of like frustrate the permitting.
This is shocking. I have lots of them.
So it's just like, I know what much about it in class, yeah, like, I don't really know all that much about it. That's basically where I got the idea from, yeah. I just, I want to test it. Yeah, I want to test it, that seems like a huge. Yeah. But so it's like, now I have to decide whether it's actually like add to it or whether I'm just gonna basically like,
Yeah, 'cause like-
Wanted to have a great story.
I just don't know what I'm gonna have a thesis on. Like, I mean, I can explain it to them, but, I mean, I don't. Had I known that?
You can
I think it's the thing I don't anymore. I just said the lowest bid. I said the lowest and I'm willing to
I'm like, okay, yeah, we all know who you're talking about. Yeah.
Jason, we start now? We good?
I think so.
All right, we're good. All right, I apologize. I usually don't like to take breaks in class, but a judge was visiting. I wanted to introduce him to the deans and the professors. They're having a reception upstairs. I mentioned the ABA is having their massive conference. They invite all the muckety-mucks with the big badges to come over to South Texas and show them around and explain to them what we're doing here. So they're having a party upstairs, which unfortunately you're not invited to. Which they have all this food for people that are not students, which sucks. But they do have interesting food. So the clerkship is 1 year. So most federal clerkships are 1 year. I clerked for 2 years in the federal district court in Johnstown, Pennsylvania. The projector's turned off. I clerked for 2 years in the federal district court in Johnstown, Pennsylvania. And then I clerked for 1 year with Judge Danny Boggs on the Sixth Circuit. So a total of 3 years of law clerking. And it was probably the best experiences. If any of you have the opportunity to clerk for either a state or federal judge, I could not recommend it strongly enough. It's a really important experience. You build a really strong bond. Judge is a wonderful guy. I'm actually giving a talk next week in Kentucky. So I'm going to have dinner with him next week. So it's funny he's here twice. I'm going to see him again so soon. Okay? Hopefully he answers some of your questions. All right. So where were we? We were talking about, the projector unfortunately shut off. We were talking about the take care clause. And I'd asked you to think about faithful execution, right? But the way I want you to approach this is similar to what Judge Boggs was talking about, is in terms of congressional acquiescence and congressional discretion. It's often the case where Congress doesn't want to take responsibility for their actions. Congress is just fine passing law that gives all the discretion in the world to the president. Why? Because there's less for Congress to do. Congress doesn't have to take positions. They don't have to make things difficult. Just pass a very broad statute. But the problem arises where Congress gives so much authority, so much discretion to the power, to the president, that when it reaches a certain point, it's like, uh-oh, what do we do? Now what? How can we get this back? So the take care clause, I think, has two different elements. Okay, the first element, if I may, does this thing work? Is what are the laws? I'll sit back down. I don't like standing here. Right? What are the laws? Might seem like a simple question. The laws are the statutes of Congress, right? Whatever laws Congress passes, the president has to execute. But the question's a lot tougher than that. Why? Because the laws passed by Congress vest the president with a lot of discretion. Right? When Congress passes these very broad statutes, giving the president a lot of authority to enforce immigration, for example, however he wants, the president can say, I am complying with the laws. Congress says, no, you're not. Who's right? Is the president actually complying with the laws or not? So that's the first part of this inquiry. And this is really what Justice Jackson discussed, the steel seizure case that Judge Boggs mentioned. Right? Did Congress give the authority to the president to take these steel mills? Jackson said the answer was no, because that was a fairly easy issue. But in the context of immigration, it's not an easy question. The immigration laws are very big, stretched over many years. Different Congresses have said different things. So it's not all at once clear in the context of immigration whether the president has this power. What are the laws? Okay? So even after you've ascertained what the laws are, you then have to think, what does it mean to execute them faithfully? Right? I mentioned this in the article, but in the drafts of the Constitution, back in the good old summer of 1787 in Philadelphia, a beautiful, beautiful hot summer, the framers considered this clause at some length. The original draft of the Take Care Clause said that the president shall take care that the laws be dutifully executed. Dutifully. Right? What's the difference? Just right here. What's the difference between faithfully and dutifully?
Dutifully seems like it's a responsibility, but faithfully is you do it with the relief in the system.
Which one's stricter, Dad? Dutifully or faithfully? Which one is a much? Which one gives the president less room to operate? That's right. So the original draft of the Constitution said the president shall dutifully execute the laws, and I think that is correct. Dutifully imposes like an obligation or responsibility, to use the word he used. There doesn't seem to be a lot of wiggle room there, right? He has an obligation, he has to do it. But Gwen, what is the meaning of faithfully? How would you understand that word?
I mean, faithfully, like Dad mentioned, there's like some type of like substance behind that. Like I would say maybe even like not only honestly and behind the faithfully, but like he believes in it too, and he's executing it because he also believes in it, even if he doesn't agree with it.
Good. So I think in terms of contract law, right? Do you remember the difference between objective and subjective? Right? Are you objectively complying with the contract? Well, maybe I think you are, he thinks you aren't, and you kind of figure out what would a reasonable person think, right? What's an objective standard? A subjective standard is what does the individual, the person enforcing the contract, think? So Angelina, would you say that this is a objective or a subjective standard?
It should be objective.
No, what does the text say? I'm not sure what you're asking. What does the text say? Just based on the text. Who decides what faithfully means?
So the president, subjective.
I think that's right. I think you have to read the text as imposing a subjective standard, right? This isn't the president violates the Constitution when someone else says, when the Congress says, no, you're doing it wrong. The change from dutifully to faithfully imposes this kind of good faith, subjective standard.
Like you said, the best of my ability, like as a president would say, it just seems like it should be more in line with the shall and the straight line instead of the best of your ability, because that just seems so far to the other side.
Okay. So, but we have a tension, right? We have the word shall in there. Shall means, like, what does shall mean? Must, right? Shall means must. So Lacey, tell me, how do you balance, and this was the question from Colin, how do you balance this command that you shall, which seems fairly objective, with this word faithfully? What does that, how do you reconcile those two phrases?
I don't know.
Think about it.
He must take care of it and how he feels
It needs to be executed.
I think that's right. He must execute the laws based on how he subjectively thinks is faithfully. So I'm sure you say this in contracts, a good faith standard, right? Remember, Lauren, in contracts, what does it mean to, enforce a contract in good faith? Generally, how do we understand that in contract law?
I mean,
Think all the way back to 1L.
yeah, let's not go there. I think when you, in good faith, it's like I am promising you that I'm not gonna try to, mess up the deal or get you out of the deal. I'm gonna do it, but I mean, like to the best of my ability. And you trust in me that I'm gonna fulfill my portion of the, of the contract and vice versa.
Okay, so let me ask this follow-up. So say there's a contract that gives some discretion, and then maybe I'll use the example that I mentioned in the article, right? Say you have a contract that says, every product that you sell at this store location, you pay me 5%, right? So say you have 2 stores, and say, in your location, you're out of a product, you say, oh, go to that other store and buy it there. But that other store, you don't have the 5% cut.
Right.
Would you say that's in good faith?
I would say.
Why'd you say that?
Because even if you weren't out of the product, you could just keep the product in the back.
No, but I'm telling you, in this case,
Oh,
it's the honest truth that you were out of a certain product and you say, go to this other store, you can buy it there that I own. Would that be in good faith?
Yeah, I mean.
Does everyone agree with that? Right? So the situation is this, you have a store, you have a contract that says 5% of everything I sell, you get a cut. Someone walks into your store and says, I want to buy that widget. It's like, oh man, I'm out of these widgets. Go to my other store across town, they have it there, right? I think everyone agrees that's good faith. I mean, look, you're not complying with the terms exactly because you're not paying the 5%, but you're trying to, at least comply with the spirit. But Jordan, let me ask you a different question. This was the example also in the article. What if you did what Lauren said, is every single time someone came to your store, you said, oh, I don't have it, go over there. And even though you did have it on the shelves, would that be in good faith? Why not? Yeah. Why is that not? Why is that not in good faith?
Good faith involves honesty.
What are you trying to do by sending the guy across town to the other store? What are you actually trying to do with your contract?
Get out of paying 5%.
Exactly. You're trying to bypass or evade the contract, right? Are you faithfully adhering to the contract, or are you going out of your way to deviate from it? You're going out of your way to deviate from it, right? This is straight contract. See, we already did adverse possession and property. Now we're doing good faith we're doing good faith here. Wait till I discuss torts in a few minutes. I'm serious. But this is the key. But you raise a very important point. 2 months ago, no one ever thought about these issues. Right? Where the heck did I get this from? I took torts. I took contracts. I took property. The reason why you're in law school, and the reason why you don't just take a bar review course, is because you learn a lot of stuff that will help you in your life in ways you can't imagine. Right? It infuriates me to no end when I get student evaluations saying, teach me what's on the bar and let me go home. Those make me almost cry. And I get those every year, 1 or 2. You're here for a reason, right? Law school is 3 years for a reason. Some people think maybe 2 years, whatever. But the things you learn in every class will help you in ways you don't understand. Did I ever think that maybe my study of contracts years ago would help me understand the President's action in immigration? Of course not. But one day I had an epiphany and said, wait a minute, the word faith is in there. Sounds like good faith in contracts. And then I did some research as, wow, it seems the framers of the Constitution saw it in a very similar way. And then you build an argument. So remember all the stuff you learn in different classes. It's not here for idle speculation. Law school has been developed for a century to teach you a set of skills. It's not just by being practice ready and learning how to draft a will, right? There's other stuff which I hope, and in this class you signed up for this, so you want to be here, which I appreciate. But a lot of people who take ConLaw in other classes, like, I don't care, I want to be a tax lawyer, it doesn't matter. So take that to heart. So the question we have here is this. Let's say that the correct standard is one of contracts, right? Is the person acting in good faith by sending the person to the other store? or is he acting in bad faith by sending the customer to the other store? And I think from what you're saying is, if he's trying to actually get around the contract, right? That's bad faith. If he's trying to comply with it, but he's out of the product, it's a good faith, mistake. He doesn't have the product. That's excusable. So I think here, even applying contract clause, you can reconcile this, right? You have a duty under the contract, shall, but you execute it in good faith. You must act faithfully. Are you trying to comply with the contract, or are you deviously going out of your way to deceive it or bypass it? All right. So Ian, how do we prove, and let's go back to the presidency, let's forget our contract example. How do we prove that the president's acting in bad faith? Don't talk about immigration for a second. But
All the interviews.
I don't want to talk about immigration, we'll get there, but I want to say theoretically, right? How do we prove that an executive, the president of the United States, the only person in the entire country who receives votes from all the people in all 50 states, how do we prove that the president's acting not in good faith?
He's not trying to comply with whatever laws Congress has given him.
How do we determine that?
I guess he's trying to bypass those laws by, maybe an executive action. He's having backing from Congress.
How do we prove that? How do we prove that the president isn't simply sending someone to a different store because he's out of products versus sending them somewhere else because they want to follow the law?
If he's telling you he's not following the law.
So his statements matter. Okay. Zach, let me ask you this question, which is a similar one, right? And let's bring immigration in slightly. The president's making an argument that's very similar to the store example. He's saying, listen, I don't have enough resources, right? I don't have the products in my store that this person wants. I don't have enough widgets to sell. I mean, there's actually, our arguments are similar. I'm simply saying, listen, because I can't send you to the store, I'm not gonna apply with the contract. I'm just gonna put people on hold for a bit, right? How do we know if the president's acting in good or bad faith when the president professes himself saying, listen, this is my faithful execution of the law? How do we know if it's not in good faith?
No, just sort of the subjective standard. I guess the best way to do it would be, I understand like in contracts, basically, bad faith is also kind of hard to establish, short of like misrepresentation, broader deceit.
So you see the problem here, right? And I know you read my article, but I'm trying to sketch this as objective as I can because I think it's a really close call. Making the take care clause something for courts to resolve is really difficult for the exact reason. How do you prove the president is acting in bad faith rather than acting in good faith and saying, I don't have enough widgets, I don't have enough resources, I don't have enough resources to do everything? Okay. What do you think, Eddie? How do you resolve this if you're a court?
Well, I'm wondering if you don't look at the words, clauses, and phrases of the Constitution, but then also look at the spirit or the legislative history or the intent, those kinds of things. And then with regard to, I guess whether or not he's going renegade and not working with the other branches.
And what happens if there's this gridlock and the branches hate each other and they want each other to, disappear? What does that do to the Constitution?
It can be proactive, but not unlimited. So he has to stay within the parameters of the Constitution and the spirit of the legislation, etc.
So you may remember, I think I showed you this slide when I did the Noel Cannon case. But there was one point in the arguments where Justice Kagan, I think I should remember this slide, where Justice Kagan said, listen, this was about the recess appointments, remember. You're not using this the way it was intended, right? The recess appointment clause was designed to deal with the situation where Congress goes home for the summer, someone dies, and the president can't fill his office, right? That's what this clause was designed for. But today, when we have airplanes and everyone can be in Washington in like a day's notice, this isn't really the emergency. And what Justice Kagan said was, you're not trying to deal with this absence of Congress as the clause was designed. You're trying to deal with congressional intransigence. This is the gridlock which you're alluding to. And the Solicitor General replied in a very candid answer, the recess power acts as a safety valve for that intransigence. In other words, when you have this gridlock, this unreasonable fighting in Washington, the president can take matters into his own hands, I think, to be proactive, to use your words, right? Is this the case, right, that this gridlock licenses the president to use self-help? Or to give you another example, torts, right? Remember self-help in contracts, torts, and property? This is the example where you're a landlord, your tenant doesn't pay rent. What you change the locks and sell the stuff. Under the common law, that's what's called self-help. You could do it. Under normal circumstances, were you to break into his apartment, you would be committing a trespass. But the breach of the lease, under the common law, said, you know what? You can trespass and steal his stuff and convert his stuff. Mike, what do you think? If the Congress acts unreasonably and doesn't do what they're supposed to do, can the president engage in this kind of self-help where he takes proactive steps?
Not if Congress has explicitly told him he can't do such things, and he himself has the knowledge that, you know, he's not allowed to do it and has admitted it on prior occasions.
What do you think, Casey?
The same thing. I think you can try going to the public more and getting everybody involved for Congress to act before just doing it more.
So the example I used with the lease, right? I said when a tenant breaches the lease, the landlord can come in and sell his stuff, right? But to use the example, instead of breaching lease, I would say breaching the Constitution. So Colin, does Congress violate the Constitution by not confirming someone or by not passing a law? Is there any constitutional violation there?
No, but isn't this where like the checks and balances would kind of come in as far as I'm not sure. I would say
Does Congress
no.
have any duty to pass laws?
No.
Why is the answer no? Does it have any constitutional obligation to pass any laws?
No.
No, why not?
Well,
Open them up, PJ. You have a thought? Does Congress have any duty to pass laws?
No, I mean, the duty is just to,
Do they have a duty?
well, I guess not, no.
Turn to everyone's favorite, page 23, right? Article in section 8. Right? You can look down with a friend. Page 23, article in section 8. This is the section which you probably spent almost your entire ConLaw class on, which was the Commerce Clause, Necessary and Proper Clause, right? What does it say? The Congress shall have power to lay and collect taxes, blah, 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 and lists like 23 different things. The Congress shall have the power to. Jason, do they need to exercise that power?
No.
Is there any obligation that they have to exercise that power?
No.
Contrast this with the executive, good old George, right? You know why his cheeks were always swollen? Because he had these fake teeth. It was actually a hippopotamus, and they always give him infections, so his gums were always swollen. Yeah, if you go to Mount Vernon in Washington, you can actually see his teeth. I'm pretty sure it's hippopotamus, yeah.
So what is the last sentence of section 8? That doesn't impose an obligation.
But which one are you reading?
Make all laws which shall be necessary and proper for carrying the case.
They have the power to make those laws, right? So if you want to read it, right? The Congress shall have the power to this, and this, and this, and this. So it's all prefaced by Congress shall have the power to. So Congress shall have the power to make all laws which are necessary and proper. They have the power to. Do they have the obligation to, Jordan?
No.
No. And this is the, yeah, Jason?
I think you might say that if what I would say is if Congress chooses to act, then they might have imposed upon themselves an obligation to make sure that they put in place the necessary and proper to fulfill their action. But if they never take that initial action, then they have no obligation to act.
I think that's right, and this is a point which people today don't seem to appreciate. All too often, the executive says, pass a bill, pass a bill. Okay. If there aren't the votes to pass the bill, then it won't get passed. But what's actually happened here, and my friend David Poston, professor at Columbia, has written about this, is that the executive's effectively taken the position that because Congress isn't passing the bills that he wants, he's licensed or he's justified in taking this kind of self-help, of taking proactive steps of bringing the Constitution and power to his own hands.
So you're saying that that isn't a default rule. If they don't do it, then he has the right.
I'm not saying anything, but this is one way of looking at the president's actions. Right?
They're interpreting, he's interpreting that, perhaps.
And I think, and I keep coming back to this answer from the Solicitor General, and I don't say this lightly, but when he says something to the Supreme Court, it's a big deal, right? When the top government lawyer makes a representation to the Supreme Court, it's significant. He doesn't just say anything. Every single sentence he says has been vetted. Doesn't always do a good job with it, but at least it's been approved by a lot of people. And when we go back to immigration, we can start with immigration for now. This is a multi-purpose presentation. I have a lot of stuff in here, but I'll just jump around if I may. When we talk about immigration, I think it fits into this mold quite well. Because what happened, right? We have an immigration system. Some people say it's broken. Some people say it's not enforced enough, whatever. We have this very complex immigration system. And over the last 30 years, 20 years, Congress has not really done much to modify it, right? President Reagan in 1986 and then President George H.W. Bush in 1990 had very significant immigration laws that dealt with the population that was here unlawfully, right? They dealt with them. They provided a pathway. Whether it was good or bad, that's not our purpose in this class. We don't really care about those things. You may, but not our desire here. But since then, several efforts to reform immigration have simply failed. President George W. Bush tried it a number of times, and it never went anywhere. When President Obama came into office, it wasn't his top priority. Obamacare was, but one of his top priorities was immigration, and it failed. So to understand whether the president's acting faithfully, I think we have to look at what is the state of the law beforehand, right? We have to look at what did the executive say about the law. I think we can also look at, did the executive say that we have the power to act, right? These are all questions which aren't set in stone, right? Justice Jackson doesn't give us the answer. But the framework that Justice Jackson gives us in the Still Seizure case is the president acting consistently with Congress? How do we decide what that means, right? How do we decide if the president's acting with Congress or trying to bypass them? And again, I think this is a close question, but I lay out in the article why I think in this particular case that, and this is a high standard, that the president is not acting consistently with Congress. All right, so let's talk about DACA for a minute and the DREAM Act. So there was a piece of legislation known as the DREAM Act. It was a bill that was being proposed for a number of years. And the purpose of this bill was to provide a pathway to citizenship for the Dreamers. These were people who came here with their parents when they were minors, unlawfully. They're not U.S. citizens, but they somehow stayed here. They've completed school, they've gotten a degree, and they haven't gotten in trouble. So these are people who, by all accounts, are worthwhile of some sort of relief as immigrants. And we can debate the policy later, but that's not important now. What's important, and I think I have Che Guevara right there. He's always there. What's important to point out is that this bill was voted on by Congress a number of times, and each time it failed. As you may know, in the Senate, you need 60 votes to clear filibuster. There was a Republican-led filibuster for the DREAM Act. They got 59 votes. So they were 1 vote shy. According to our Constitution, unless a bill passes both houses, it's not law. If you want to argue the filibuster is unconstitutional, we can talk about that after class. But until the Senate abolishes the filibuster, which they can do, those are the rules we play by. 60 votes. Okay? So we had this contentious debate, and the DACA failed, the DREAM Act failed. The president had supported this bill strenuously. He kept saying that our immigration system is broken and we need to change it. The president also said many times beforehand that he lacked the power to unilaterally suspend deportations. He made this point emphatically clear many times. There were a number of town hall meetings where he was on TV, on Univision and Telemundo and various Spanish language channels. And people said, you know, why can't you just wave a magic wand and halt the deportation of the Dreamers? And the president said, which I think is probably right, I can't do that. I'm not a king. I don't have the power to do that. Over and over again, this is like, you go through the articles like a dozen times he said this. Okay? So let's take off our presidential hat for a minute and let's put back our contracts hat, right? Chris, right? So you're a party to a contract, right? And it's maybe clear or unclear whether you have some discretion to do something under the contract. If you say over and over and over again to your lawyer, man, can I do this? And your lawyer says, sorry, you can't do this. So then you say, you know what? I can't do this. Let's renegotiate the contract because I can't do X under the contract, right? From a subjective perspective, what does that tell us?
That he's willing to renegotiate
Why is he willing to renegotiate?
because he knows that he can't do it without breaching the contract.
Exactly, right? If you go to your lawyer and say, hey guys, can I do X under this contract? The lawyer say, sorry, you can't do this. If you want to negotiate a new contract. In this context, president goes to his lawyer to say, can I stop deportations for the million Dreamers under the existing law? And they're like, no, sorry, you can't do this, right? Go to Congress, get a new statute. Okay. So as far as a subjective proof, this seems like pretty good evidence that as a subjective matter, the president says, I can't do this. And this is fairly rare. And it's particularly salient because the president's a constitutional law professor, right? I'm not just making this up. If you actually read Justice Frankfurter's opinion in Youngstown, he attaches a significance to some presidents are lawyers and some are not. In fact, the president himself has said that as a constitutional lawyer, he has a special say in this. Other members of Congress who aren't lawyers don't. I think that reeks of hubris, but apparently, you know, this is how it rolls. Okay. So when a president disclaims a power to do something over and over again, you can see the quotes. Subjectively, that tells me that maybe he doesn't have the power to do it. But then, once the new legislation is defeated, in other words, once they realize he's not going to reach a negotiation, the president goes to his lawyers. And we don't know what happened, but imagine the conversation went like this. It goes like this. Like, well, the president says, well, remember when I asked you if I could stop deportations and you said no? Yeah. Try again. Think harder. See what else you can find. I mean, one day you will be a lawyer and your client will come to you and say, can I do X? And you're like, no. And the lawyer says, look at it again. What's the client asking you at this point?
Must do it again. What is it for me?
What's the client? What's he asking the lawyer to do at this point?
Basically, try to find any possible way or any way to spin it to the client
Exactly, right? There's not necessarily anything wrong with this, right? You will all be lawyers. You're bound by duties of legal ethics. Hope you take your legal ethics class and honor them well. But you have some latitude, right? You have some room to make arguments of varying degrees of goodness, shall I say, right? There are some arguments that are better than others. Will hold up in court. I mean, that's the risk, right? If I go to a lawyer and say, hey, go think harder, and they give me some garbage argument that gets thrown out in court, I'm on the hook. And they'll probably blame the lawyer also for it, right? But that's how our profession works. It's not much different in the executive branch. The president has his lawyers. He's on it's called the Office of Legal Counsel. These are the top lawyers in the government. These are former Supreme Court clerks, really smart people, really smart people. But at bottom, their duty is to their client, who's the president of the United States. It's funny, President Obama was on the Colbert Report on one of the last episodes. Have you watched that show? And Colbert asked him this question. He's like, well, how do you keep yourself honest from taking too much power? And the president said, well, I listen to my Office of Legal Counsel. And I make sure that they give me, stop laughing, and make sure they give me honest advice. And he said, so it keeps him in check. But, and I'm sure you can guess at this, when the Office of Legal Counsel said no to him the first time, and he went back and asked again, they get the memo. So in the article I sent you, I've referenced this Office of Legal Counsel memorandum, which I didn't make you read. If you want to read it, it's on the internet. It's about 20 pages. But the development of that memo is really interesting. So that memo was effectively written over the summer of 2014. This is really new. This is like last summer, right? And the New York Times reported that this policy went through 60 iterations. 60 iterations. Each time his lawyers gave him something, the president said, go further. Not far enough. Not far enough. Push harder. Go further. 60 iterations until he was satisfied with it. Okay? This isn't the case where I go to my lawyer, Gwen, and I say, Gwen, can I do this? And Gwen says no. I say, well, look a little bit harder. And Gwen says, really, I mean it, no. Right? Gwen, what do you make of the fact that this went through so many different iterations, each time the executive was trying to push it further and cover more people under this deferral? What do we make of that fact?
Just seeing how far he
Do you think he saw a limit?
eventually after 60 back and forth.
So that's right. Jason?
Yeah, I mean, it's just that it's curious that he only went as far as he did with DACA. And then, why with DACA did he not include the parents? Because he got so much pushback, but then ultimately came back, and pushed it even further.
Why do you think, and let's look at this exact question. After the defeat of the DREAM Act, so Angelina, after the defeat of the DREAM Act, right? The DREAM Act was defeated in 2011. He implemented DACA, which was for the childhood arrivals. To answer questions, why do you think he didn't extend it to the parents? Why do you think he didn't extend it to the parents? Why do you think he only limited it to the dreamers?
Well, the children don't have a choice in the matter.
Policy-wise, why do you think after the defeat of the DREAM Act, he limited the executive relief to the dreamers?
He's almost there.
Yeah?
Just enough votes.
Laura?
Well, I mean, like, people are gonna have more pity for children.
Now, I'm not talking about the policy. I think Gwen was on the right track.
Like the people, like 59 votes, you are one vote away, we already had most of the support
Yes.
needed.
Colin, your hand up?
Yeah, I think, and the fact that, well, and that's more, what I think is more policy.
Anyone else on that point? I think that Gwen's a good point. It got 59 votes. Cleared the House, got 59 votes. In the president's mind, this should have been law, right? In the president's mind, in a reasonable Congress, this would have been the law, right? So you know what? When you have this unreasonable Congress that's acting like a bunch of babies, let out a little bit of steam. Help out these kids for a couple years. Put them on hold so you don't deport them. And the president said as much, and there's a footnote somewhere in the article, I don't remember exactly where it is, where he says something like, this bill passed the House and almost passed the Senate. He's looking at the fact that a bill should have passed but didn't as a justification for this action. So Lacey, I'm going to ask you a tough question. Under Justice Jackson's theory, is 50 votes in the House, I'm sorry, is 50% in the House and 59 votes in the Senate, is that sufficient to indicate congressional support? Under Justice Jackson. I'm not talking about bicameralism presentment, right? This is not INS v. Child with a line on veto. Jackson looks to congressional support. 59 senators and half of Congress, half of the House. Is that congressional acquiescence from Congress? Why not? Well, don't guess. Tell me. What do you think? Lauren, what do you think?
I think, no, I think it's not enough.
Why not?
Because Constitution says
What does the Constitution say?
60 votes, correct?
The Constitution does not say 60 votes. It's nowhere in the Constitution.
Sorry.
What does what do you need to pass a bill?
Majority.
Majority, Jordan, majority of both houses, right? 60 votes comes from a rule in the Senate. That's not in the Constitution. Can the president treat majority support in both houses as support for his action? He seems to think so.
I think so.
I think, there are arguments on both sides, right? The Republicans say, wait a minute, you didn't get to 60. And he says, well, I got 59. That's more than 50. And we're not talking about is the DREAM Act law. It got defeated. But it had significant social support. And I think what you'll find is that after DACA, did anyone file lawsuits? Did Congress try to sue the president over DACA? Did anyone make a fuss about it? The answer is no. Ian, why do you think no one made a fuss about DACA after it happened?
Well, isn't it because it said it was only for like 1 million, it was before you expanded it?
Well, let's just talk about DACA in 2012, right? Why do you think people didn't file any lawsuits over this? This goes to the policy, which I should have put people down about this.
Children.
Yeah, think of the children, right? This enjoyed majority support in the country. It basically came within 1 vote in the Senate becoming law. No one filed lawsuit. Because people liked it. People liked that the executive was able to take unilateral action because they liked the policy results. So one of the things I want you to do in this class, and I'll repeat this over and over again, is try to separate your policy preferences from the Constitution, which is very hard. And I'm sure I fail at it every day of my life, but I try. So whether or not you support DACA or the DREAM Act, and as a matter of policy, I think it's probably a good idea to help out people who didn't come here on their own will, right? Who came here with their parents, right? These aren't people who knowingly came here, right? No one complained. So Zach, the fact that the president did this and no one complained, how do we look at that under Justice Jackson's framework? Judge Boggs alluded to this a couple minutes ago. Yeah. Exactly. Why isn't the zone of twilight?
Because it's really unclear. It's kind of like a middle ground to scrutinize the actions.
Did Congress approve of DACA?
It's not really clear.
Did they try and defund it? Did they take any votes to condemn it as it's happening now? Okay. I'll tell you who did complain about was Justice Scalia. So if you read his dissent in a case called Arizona versus United States, it was decided about 2 weeks after DACA was announced. And Justice Scalia must have modified it. I was actually in the court when it was announced, and he was livid. He said something effective, I'm paraphrasing, it's come to this. The federal government will no longer enforce the law, and sues the states when they try to help. Scalia said it very clearly in that decision, that the federal government has stopped enforcing the law with the DREAM Act. So at least one person was upset. But Congress didn't do anything. We had an intervening presidential election. This wasn't really an issue. Neither Mitt Romney nor Obama really talked about it much. Right? So DACA is in this weird stage, right? You know, I think it was unconstitutional for a lot of reasons, but people didn't seem to mind. But DAPA, Deferred Action for Parental Accountability. This was the 2014 one that happened like, what, 3 months ago. This one has a similar origin, but a very different reaction. All right, so what happened with DAPA? After the defeat of the DREAM Act, the president was trying to push another piece of legislation, which was often called comprehensive immigration reform. All right, what's this comprehensive immigration reform? I mean, the sign says it. It's a pathway to citizenship for roughly 11 million people who are here unlawfully. And again, we can debate this good or bad policy, not my class. You can debate it in another class. The bill passed the Senate. So if you recall, the DREAM Act failed in the Senate. This one passed in the Senate. Beat the 60-vote block, got over 60. It didn't come up for a vote in the House. Right? Why? Because this is a very controversial topic for Republicans. That a midterm election coming up, a lot of Republicans didn't want this. So John Boehner never brought it up for a vote. By failing to bring it up for a vote, they don't have to take a vote that goes in the record one way or the other. Okay? So never cleared the Senate, never even got for a vote in the House. This bill, unlike the DREAM Act, is a little bit less popular. With the DREAM Act, you're talking about children who came here with their parents and they didn't really know what they were doing. They didn't have the mens rea, if you will, to break into the country. This, on the other hand, impacts people who willingly came to this country without permission or overstayed a visa or a countless number of different mechanisms by which people come to this country. The equities were different, if you will, between the dreamers and the millions who came here unlawfully. Okay? But in the same fashion where after the DREAM Act was defeated, the president launched DACA, I get confused. Here, after the defeat of this immigration law, the president also took action. So on the same day, the very same day that the House of Representatives said they wouldn't bring up for a vote, the president held a impromptu press conference in the Rose Garden. And he announced, in no uncertain terms, that the immigration system is broken. Congress didn't fix it, so I'm going to fix it myself. And he said, over the summer, I will release new proposals to fix immigration. Now, he didn't actually until after the election. He waited until about a week after the election. And you can take that for whatever it's worth. Right? So again, Congress didn't vote for the law he wanted. Voted down. And then he said, I will do something by my own. Now, preceding this, and I discussed in the article at length, people asked him over and over again, can you suspend the deportations for the parents of U.S. citizens? Can you halt the deportations for the parents of the dreamers? Can you halt deportation for these different groups? And over and over and over and over and over and over again, the president said, no, I cannot do that. He said it more times than you can count them all, like a dozen times. Magically, over the summer, after 60 iterations of this policy, they suddenly discovered the power to do this. Right? So Mike, how do we think about this under the Take Care Clause? How do we approach this question? Again, it's not an easy question.
Well, I think even with the first iteration, he knew he wasn't allowed to do it. So each subsequent iteration, I would say, was done with more and more bad faith in mind.
Malice aforethought or something, right?
That's what I would say.
Let me ask Casey. Why don't we give the president? Why don't we say, or what if it's possible that maybe his lawyers just thought of something they hadn't thought of before, right? You know, the same way maybe I think of some new legal arguments when someone gives me a question. Sometimes you ask me a question, I think something new. Why don't we give the benefit of the doubt to the government lawyers? Because maybe they discovered a new question. Maybe they discovered some new way of looking at the law.
Because even if they did, it's his duty to faithfully execute when he knows strictly is right. And Congress didn't.
How do we? No, but you're avoiding the question. What if his lawyer said, "Here's a way that you can faithfully execute the law and not deport these people"? They discovered some fancy new legal argument that they hadn't had before.
Then he's right in the bill.
Then he's what?
He should try.
No. But what if his lawyer said it's within your existing discretion to do this? They found a new argument. Is that would he be acting faithfully then?
Mm-hmm.
So here's the issue, right? And this is why this is such a tough case. How do you prove the president's acting in bad faith? Maybe his lawyers were just smarter than other lawyers, right? Maybe his lawyers looked at this in a different way and they discovered something new they'd never discovered before, right? Maybe they found a new argument that had never been thought of. What do you think, Colin? Is that permissible? Should we excuse the president for making that kind of argument?
No. My gut reaction was just to say that you have to look at what you think his intent is or what his demeanor as a whole is on the subject. But when he's been under a microscope, no, I don't think that he should be excused. I'm not sure.
PJ, what do you think? How do we determine if the president's acting with bad intent or bad faith? When he says, look, I have this 20-page memo. My lawyers found it. They wrote this beautiful memo, which gives me a justification. How do we deal with that? What is that? Can we ever say that that was in bad faith when he puts forward a 20-page legal memo explaining his actions?
Yeah, I feel like I almost feel like bad faith is kind of an obvious thing.
How much time has lapsed?
3 months.
Yeah.
When you look at the totality of the circumstances, I mean, obviously the election matters, and obviously all these other timing-wise, it just you can't pinpoint and say 100% bad faith.
If he wasn't doing anything wrong, why is it not like okay with Congress? Like why didn't it come out the new justification for it that his lawyers found?
Well, he did. He released his memo the same day he announced the policy.
So then it should all be okay.
Well, that's the question, Mike.
I agree with the totality of circumstances argument. I mean, if he hadn't said that he knew he wasn't allowed to do it, it's like, I'm not the emperor, I'm not the king, I'm not allowed to do it. And then he waited until like, the bill didn't get passed. And then magically, they just find this.
Why do you assume bad faith? Why do you say magically? Maybe his lawyers actually came up with a new argument that hadn't been done before. Is that so implausible? Is it so implausible to think that these really smart Supreme Court clerks can come up with a legal argument?
When you factor in everything else, I think yes.
And after this has been an issue for more than 3 months, it just seems like.
So you don't believe
it's
him?
not excusable.
You don't believe that the memo was in good faith? You think the memo was some sort of strained legal reasoning?
It wouldn't have taken him 60 times to perfect.
Okay.
I think like even if he had a memo, does it still like the people who are represented, like they voted a certain way, even though he found some way around it to do it? Is that really doesn't mean it's right?
What if this memo, no matter how unpersuasive it is, and let's say the memo is not persuasive, like maybe it is, maybe it's not, but let's say it's unpersuasive. What if the president actually believes it? So you know what? I read this. I'm persuaded. That makes sense. Jason, what do you think? President reads like, that's a good memo. Okay, I'm going to do it.
I think that's his, best argument that he actually believed that this was a faithful execution of the law. But I think in determining whether or not, in the court to determine whether.
Whoa, I didn't get to the courts yet.
Okay.
That's my next question.
Well,
Let's just say in the abstract, between us friends, right?
well, then I was gonna use the third tier of Youngstown, but, to determine, whether or not he's.
Yeah, but if the press, I mean, Chris, let me ask you this question. The press says, you know what? I read this memo beforehand. I didn't think I had this power, but after this memo, damn it, they persuaded me. Isn't that the end of the story?
Because I think he's still, Congress still already said no, and he's still going against it, so I still think he's acting.
Yeah, but he thinks he's acting consistently. The memo tells him he is. The memo says you can do X. He's like, I read this memo, and man, this is a good memo. What do you think, Dad?
Sometimes we can tell bad faith by when and how you do it well.
Good.
So when did he have the memo? He keeps saying that, I can't do it, but right bang, after the election, he came out with it. So that could show bad intention.
So this is what we call extrinsic evidence, right? You never thought you'd hear that word ever again. Contract. Remember the statute of frauds? The extrinsic evidence. Remember what extrinsic evidence is? When you're trying to figure out the terms of a contract, you look outside the contract to figure out intent. So the surrounding circumstances that mentioned, look, we had defeat of this bill. We had all these statements saying he can't do X. We had an election that happened 2 weeks later, he issues his policy. All these factors point, in my mind, in one direction. That he didn't necessarily buy the memo. He didn't think it was a good memo. He thought, well, this is something to hang my hat on, so let me go with it. It's something. So I mentioned, I think I did this a few weeks ago, hostilities, right? Remember, discussed with the War Powers Act, where the president was engaging in bombing of Libya. And the War Powers Act says that you have 60 days. Hostilities cannot last more than 60 days. If you go beyond 60 days, you need the permission of Congress. Congress has to approve it. So here's what happened, right? And so that mentioned extrinsic evidence. Let's talk about the timing. So we're coming up on the 60-day clock, right? You know it's going to hit. The president asks his Department of Justice, can I stay beyond 60 days? They say, no. The president asks his Department of Defense, the Pentagon, can I stay beyond 60 days? They say, no. The president asks this guy, Harold Koh, who was a former dean of the Yale Law School. Hey, Harry, so old friend, can I stay beyond 60 days? He's like, well, yeah, you can. Because the bombing the crap out of Libya is not actually hostilities. Therefore, the War Powers Act doesn't apply. Okay? So he got an opinion he got a memo from Attorney Koh saying that, yeah, you can stick around. Gwen, is this bad faith? What if the president says, you know what? I don't think my Justice Department got it right. I don't think my Defense Department got it right. I think Harold Koh got it right. He had the best memo of all three. How do we respond to that?
I feel like he's just grasping for straws in order to carry out what he wants to do. So he's gonna find a way to do it.
And isn't that always the answer, right? If you're a client, you can find a lawyer to sign off on whatever you want. This is especially true in the executive branch. If the name John Yoo rings a bell, he's a friend of mine, but he issued a number of memos while he was in the Bush White House, which justified various forms of enhanced interrogation techniques, which you may call torture, right? You can find a lawyer to justify just about anything. And it's here that I think the word faithfully carries some weight. Are you simply trying to find some argument to justify your actions? Or are you actually trying to comply with the law? I think this evidence in Libya, where he went to his mom said no, he went to his dad said no, he went to his grandma said, oh, sure, honey, whatever you want, right? Grandma Koh, so to speak, gave him what he wanted. Is this acting in good faith? Based on the timing where you're running into that 60-day clock and everyone else in your cabinet told you no, and you find one guy who says, yes, on a very weak argument that I think I said a first-year law student wrote that in my exam, I'd fail. If a first-year law student said bombing the crap out of Libya is not hostilities, I'd flunk them because I say you need to drop out of law school or go take a reading comprehension test or something, right?
And then he'd be writing memos for the White House.
It's not, yeah, I guess it's not that hard to get a job there. But it raises the issue. What happens when the president agrees with very dubious legal memorandum? Even the Noel Canning case where the president made the recess appointment during a 72-hour break, he had a memo. The memo said, oh yeah, sure, you can do that. All 9 justices said you can't. When Justice Ginsburg is telling you you've exceeded the executive power, you're really in trouble, right? You're in a bad place when Justice Ginsburg says you can't do that. Eddie?
I mean, I can hear the conversation, him saying, find me an argument.
Find me something.
Which is what, you hear in these hallowed halls periodically. Find me an argument. What is your argument? So sure, they're going to, but yet on the other hand, there are parameters and guidelines that they have to stay within.
What are those parameters, Eddie?
Well, it's think about who determines those parameters. Who's going to assess the validity of their argument, the legal reasoning of their argument? Is it going to be the courts?
Ah, okay. And this brings me to my final question, right? It's all well and good, not final question, my next question. It's all well and good for us to sit in this classroom and say, well, it's good faith and bad faith. But the question that is before the court right now, in the case of Texas versus United States, I love this picture. Texas versus United States, right? And again, I mentioned this, but I filed a brief in this case, so I do have a position, but I'll do my best not to be bound by that. Should the courts be in the business of determining whether the president's acting in good faith? In my article and in the brief I wrote, I marshaled a lot of evidence about the timing of this, but the president's statements about how the bill failed and out of the ashes like the phoenix, these executive policies arose. Angelina, should courts get involved in making these kinds of determinations?
Rephrase the question.
Should the courts be in the business of trying to piece together the political consequence? Like, okay, so then you had the bill was defeated, then you had the election, and then you had the policy and all the iterations. Should the courts be in the business of actually making these decisions?
Well, we rely on them to kind of analyze the decisions that have been made, and so I mean they're part of the separation of powers, and that branch is just as important and fundamental as the other two are.
What are the risks of the courts getting involved here? What are the serious risks?
I'm not sure if you're going in this direction, but as far as maybe giving advisory opinions or something like that.
Maybe. Explain more. What's the problem with advisory opinions?
Well, they're not supposed to give advice.
What are they supposed to do?
I don't know how else to word it. They're not supposed to give advice, though. They're supposed to apply the law.
Okay, Lacey, what do you think? What's the danger? What's the risk of letting the courts get into the muddy waters of saying, well, the bill was defeated, then you had an election, and then you have all these iterations, all this stuff? What's the risk there?
It just opens the floodgates for a lot of stuff coming in that not necessarily Congress agreed with president's provision.
What are these floodgates? What could happen?
Well, I mean, the bills aren't passed and, anything done, it would just open the floodgates for the judge, anybody to sue to say, we don't agree with the way, whether this was subjective or faithful, we don't agree with the way it, went and was passed. It's just.
Mm-hmm. Lauren, what do you think?
Sorry, I'm just reading.
You can look at the map. It's online. If I look at it later, I'll show it. So what do you think? What's the risk of the courts getting involved in these kinds of really political disputes? Right? I mean, we're having a borderline political science discussion in this class, right? What's the risk here of the courts getting involved here? Are there standards the court can use to actually resolve this issue?
I mean, I don't know. As far as the courts getting involved, I think while obviously like the president appoints, the Supreme Court and that kind of thing, but it's in there, but they're for term, so even if, like we were saying at the very beginning, like if somebody passes away and he appoints somebody, you can't really get that. But I'm saying like, it gets so political between the executive and the legislative, and those two kind of, going back and forth over if there's the majority in that, in Congress, and then there's the president, and if the courts get involved, then I feel like they feed, the risk of them is like feeding the beast, I guess.
Oh, Lauren, let me ask you this question. Say the court says, I'm not going to get involved. They say, you know what, this case is dismissed. Supreme Court says, I'm not going to take it. What's Congress's remedy if the president violates the take care clause? That's your favorite answer, isn't it? I think you said that every single class. Yes. But here it's actually relevant. Impeachment, right? If president violates the Constitution and the courts don't get involved, the Constitution has a mechanism for that. It's called impeachment. Jordan, what other remedy can Congress use to nudge, shall we say, the president to comply with the law? Jordan?
Yeah, I mean.
What's even before impeachment? What's a less drastic remedy than impeachment?
Well, I mean, yeah, like you said, power of the purse. I mean, they can defund stuff.
But what happens when Congress defunds stuff? What results from Congress defunding stuff and not passing a budget? Jordan, one at a time. What happened last fall 2013, when Congress and what happens when there's a government shutdown?
Basic services. I mean, not in that one, but it could be the basic services would be provided.
Okay, so there are political costs here, right? When there's an impeachment that will never succeed because you need 2/3, and the president's own party will never vote to impeach him, right? So you have a failed impeachment. We tried this with Bill Clinton, it didn't work. And it was a very unpopular event. So when Congress tries to use impeachment, there's political checks on it. What when Congress tries to use the power of the purse? Results in a government shutdown. People can't go visit their national parks, and they get angry. And there's a political pushback. So the mechanisms the Constitution builds in, impeachment and the power of the purse, are unpopular. And there's risks, right? Ian, what are the risks associated with a lawsuit?
You could lose.
Is there any political consequence
Oh, yeah.
in the terms of popularity following these lawsuits?
Like main motivations to get reelected, so people.
Do you think people at the budget, at the ballot box, remember a lawsuit being filed?
No.
Do you think people at the ballot remembered, wow, I'm a federal government employee and I was furloughed and laid off for 6 months because they shut down?
Yes.
Do you think people remember, it's like, wow, they tried to impeach the president with jerks?
Yeah.
You see where I'm going with this, right? By shifting the burden to the judicial branch, Congress can brush itself off of whatever political consequences. It's easy. Go hire a lawyer and file a lawsuit, right? Challenge this in court. No sweat off my back. In fact, I mentioned that the House of Representatives is trying to sue over Obamacare. There was actually an article in the Times the other day that said that they might consider suing over immigration, right? Why would the House of Representatives sue over immigration when the Texas case is already far along? I mean, a judge in Brownfield is going to issue a decision probably next week or so. Zach, why do you think the House of Representatives would want to sue over immigration when there's already a lawsuit going on?
Try to displace citizens' dissatisfaction with federal government.
Exactly. The article I read said this was a cover, right? The House Republicans aren't going to stop Obama's immigration bill. They can't. They don't have the veto-proof majority. Anything they pass will be vetoed. But following a lawsuit, they can go to their constituents, hey, look, we filed this lawsuit. And what if that lawsuit gets dismissed in 6 months? Oh, whatever, we did something. So I think here there's a severe risk of Congress shifting to the courts their own baggage, right? This is a problem of Congress. They don't want the political consequences of impeachment. They don't want the political consequences of a shutdown, so they file a lawsuit. Right? You see the problem here, right? They're shifting all the costs of this on lawsuit. But, and again, I filed a brief in this case, so I do have a position on it, but this doesn't mask the fact that the Constitution is being violated, right? although I'm sure there are very many cynical and political motivations for bringing these lawsuits, these actions have costs on the state. They impact the states. So in thinking through whether these lawsuits are a good or bad idea, be aware of the fact that they're often just viewed as partisan tools. But keep in mind that if in fact there are constitutional violations, there's not really a way to declare it other than the courts. Think about it. Even if they impeach the president, right? Does that set a precedent for the future? Is that like a case law? Is that like Youngstown where presidents say, well, I can do this or can't do that? Impeachment's a very political aspect. If Congress passes a bill defunding the president, does that set a precedent of what the future leaders can do or not? Is that like a case in a book? So we have judicial precedents. We have these rules. We have the Steel Seizure case. And every president since Truman has said they're going to abide by that. So there is some value to have a judicial declaration of what the limits are on executive power. But I think there's a very distinct risk, which I think all of you have recognized, of what happens when the political branches dump in the lap of the courts the problems they don't want to fix themselves. And I don't know the right answer to this. Again, we are in fairly novel territory. We don't have a history of states suing the federal government over non-enforcing the law. We don't have a history of the House of Representatives suing the president over non-enforcement of the law. We don't have that history.
And I guess the other question is too, is like, okay, so say the House and, you know, they go to, let's say the House and the president go to the Supreme Court.
Mhm.
They're gonna make a ruling. Somebody is gonna be unhappy. So won't that just make it even worse by making it, well, now the Supreme Court only, supports Congress, or the Supreme Court's only gonna support the president, and I mean, that's precedent.
Right. So
it would be a precedent to the fact that if the president and Congress disagree, the precedent is that the Supreme Court's gonna back Congress. The precedent is, or the other way around.
what if the Supreme Court says, we don't think this is a case we should take, there's no standing? We haven't talked about standing, but what we say, we don't think that Congress, the president, there's no injury to the states, no injury to Congress. We want to decide this on the merits. What precedent does that set?
They're doing the same thing that Congress tried to do, is they will push it off on the courts, and the courts is saying, well, we're gonna push it right back on you, we're gonna say you're not standing.
So at the end of the
Back to
day,
square one.
who wins in this case? Which branch of government, this is Justice Scalia's point, Noel Canning, over the generations, which branch of government wins by accumulating power? The executive. Why the executive?
Because all Congress and the judicial, all legislative and judicial do are just washing it back to each other.
They don't want responsibility. Eventually, it all falls back on the chief executive, commander-in-chief. Which is perhaps all the more reason why the courts may have a role to get involved to reassert that. All right, Justice Jackson's concurring opinion, again, he wrote this after being a prosecutor of the Nazis at Nuremberg. He said, listen, we've seen waves of tyranny go through Europe. We've seen how these democracies in Germany ushered in despotism. And his last sentence, Judge Boggs mentioned the cartoon about Youngstown. The exhibit also had his draft opinions. But the last sentence of Youngstown, Jackson says, the courts will be the last, not the first, to relinquish that defense. The last and not the first. So even if Congress has already given up their authority, and Congress didn't object to the Steel Seizures, Jackson said the courts will be the last and not the first to reassert it. All right. Any other questions? No? All right. Have a good day. I will look forward to all of your submissions on Sunday night, and I'll see all of you next week. Thank you.
Are we gonna see the Blackman Boggs?
Yeah, come up. It's on YouTube. It's on YouTube. I'm recording. Anyway, all right. Any questions? All right. I'll see you all later.